Okay, we are live.
Okay, this is the so-called bail bill S-27. And Michelle is here to walk us through the redraft. It's draft 3.3.
Good morning.
Good morning.
I'm going to share my screen. Everybody see that okay?
Yep.
So section 1, I'm going to go down so you have your introductory language on subsection B on limitation of bail. So you'll see, and I've reworked this section a little bit. I was working with Rory a bit yesterday back and forth to get the language correct. And so you'll see the intro language on lines 20 and 21, no bail may be imposed. And then top of page 2, at the initial appearance of a person charged with a misdemeanor offense or upon the temporary release pursuant to Rule 5B of the Vermont Rules of Criminal Procedure of a person charged with a misdemeanor offense. And then moving on to line 8, except where the court finds that imposing bail is necessary to mitigate the risk of flight from prosecution for any of the following offenses. And then that's your laundry list of your misdemeanor listed crimes. In addition to I added on lines 19 and 20, misdemeanor cruelty to a child. We talked about last time, that's a 2-year misdemeanor. And then you also have this subdivision G at the top of page 3 on lines 3 and 4, which again is not a listed crime, but is a misdemeanor crime of violence elsewhere and other definitions in statute. And so those are the changes to this section 1. Do you want me to pause with each section?
Yeah, I'd make sure that if there are any comments, either from the audience or, which I can't see, so you'll need to speak up, or from any committee members. I guess we can move on.
So section 2 is your proposal to eliminate cash bail. And what I've done, the only changes to this are going back to the original kind of directive for the study that was in the bill as introduced. So you have the Vermont Sentencing Commission in consultation with the stakeholders that are in subdivision 2 that you saw last time you took this up. And the charge is on lines 11 through 14. So they're to identify the conditions that would be required to move toward the elimination of the use of cash bail for the purpose of mitigating risk of flight and to develop a proposal to eliminate cash bail.
Okay. I think I know what it means. The directive is to come up with alternatives to mitigating the risk of flight other than bail.
Correct.
And I have no idea what those might be.
That's for the Sentencing Commission to figure out.
As a member of the Sentencing Commission, if somebody said, well, what are some of your ideas? I said, well, I guess in some cases taking their passports might do.
Hopefully the national leaders in bail reform will be able to help support that work.
That's all. But just so that anyone out there listening to this has to do where cash bail is, it doesn't change the ability to hold people without bail in danger under the current system.
Correct. Yeah, there's no...
Even the proposal doesn't suggest that if somebody were eligible to be held without bail for a certain crime, that they couldn't be, even at whatever the Sentencing Commission comes up.
Right. I mean, if you would feel more comfortable with a reference to that provision.
No, I don't think I need that personally. Okay. I just wanted to make clear to anybody that we're not, this only affects those individuals who are eligible for cash bail. Certain individuals, because of the dangerousness or the weight of evidence, you can withhold cash bail. It doesn't change those situations. That's all.
Okay, no changes to section 3 on the directive to the judiciary to develop a proposal for notice of hearings. And then no changes to the effective date section. You still have section 1 taking effect on July 1st of 2025 and the other ones taking effect on passage.
All right. Are there any comments from anyone in the audience regarding S27 as it now stands? Draft 3.3.
Doesn't look like we have any in the room, Senator Sears.
Oh, okay. I see we've got some people online, I guess, on Zoom. All right. But there's nobody in the room. Well, the 3 committee members are
Here.
So, is there a motion to report favorably? Oh, Matt Valerio's in the room.
Matt, I asked him, he doesn't want to comment necessarily.
I move that we find S27 draft 3.3 favorable.
Okay. Motion is to report favorably S27 as amended and seen in draft 3.3. Is there any further discussion? Hearing none. Peggy, could you please call the roll?
Senator Baruth,
Yes.
Senator Norris,
No.
Senator Bihowski,
Yes,
Senator Hashim,
Yes.
Senator Sears.
Yes. I was actually gonna vote no when I first looked at the bill, and I appreciate the effort at the committee in coming up with a compromise with not certain violent misdemeanors. Senator Bihowski, would you like to report this bill?
I
Since
would
you
love to
introduced it?
report this bill.
Great.
Michelle, does it have to go through editing or are we all set?
You are all set.
Awesome. That never happens. I'll
Who's
get-
going to take up the forensic bill? Can somebody
Yes.
take that up on my behalf? Peggy,
Yeah.
can you do it?
I can take it up, Senator
Yeah.
Oh,
Sears.
okay. Thanks, Bill.
Yeah, I think it'll be a while before we get it. Senator Baruth, but I will find you.
Okay.
Eric is due at 9:45.
He is able to join us earlier if you'd like.
Yeah, I'd like that.
Okay, I'm gonna have him join now. Hopefully the witnesses are listening and they I'll try and send a quick email out to the. All right, Eric, I believe is on his way. And I'm just gonna try and let the witnesses know that we're starting early in case they wanna.
Aren't we just buzzing through things?
Yes, we are.
Also, what I was gonna say on this bill is I didn't expect it to take a terribly long time, but I felt like if I said that before we did the bill, all hell would break loose.
Yeah.
Okay, I'm gonna let them all know. All right, I let the witnesses know, so they can make it, they join. And Eric, I believe, is on his way. And here's the leaves.
While we're waiting for Eric, this is as you all know, this is an annual bill, but it often takes on new issues towards the end, and this year's been no exception to that. And I'm glad that Judge Zone realized we were sunsetting the Sentencing Commission before we gave it more duties. those types of things are what miscellaneous is all about.
Hopefully we can buzz through this afternoon here quickly too.
I don't know if it's gonna go quite as quick and smooth this afternoon.
Yeah, you guys have.
So we're live, because just so you know,
Oh, wait, I got three.
we're still live.
What's that?
Is Judge Zone available? I have a question, Judge.
Call Senate. 1:30.
Maybe Eric knows the answer.
We got-
He's
I'm
on
available.
one right now.
On the Sentencing Commission, I know the membership is the chair of the Senate Judiciary Committee and chair of the House Judiciary Committee. Is there an opportunity to appoint a designee rather than the chair?
I believe so. I can check that right now, but I believe absolutely.
So I told her.
I'm frequently unable to make the meetings, and I was gonna ask Senator Baruth to take it to the Committee on Committees to see who should be a member, particularly with some of the more important things that we've got going on this year. In the Senate.
Actually, you might want to add that to S33. It says the chair of the Senate Committee on Judiciary. So you may, that would be Title 13 VSA 5451 subsection B.
Okay,
You might want to put that in or designate.
or
Yeah, virtually
could
every
be
other
the chair
position.
or vice chair. That would work too if the vice chair is willing.
It's interesting because virtually every other position says or designate at the end.
Yeah, my attendance has been generally very spotty, and
Just had a,
is the committee opposed to having that change so that either the Committee on Committee does it or the chair or vice chair?
we're designated.
I'm sorry, Senator Shears, I couldn't hear you or what the change being proposed was.
Well, the change would be to the Sentencing Commission. The only members of the commission that aren't allowed to appoint a designee are the chairs of the House and Senate Judiciary Committees. And I was pointing out that I frequently am not able to make it, and it might be better if the vice chair or chair were the designee member, so that or some other either or that the Committee on Committees appoints someone.
I think if you just add or designee,
That seems reasonable to me.
Open-ended, like that better.
because, just looking at the last week, we had instances where we had chairs and vice chairs out.
Yep.
So it'd make life easier if you could just designate.
Okay, sounds good.
Eric is here.
So Eric, that would be a floor amendment.
Very clear on what he's talking.
I don't want to screw up unless you can get that in there before we try to send the draft 2.1 up.
It's probably pretty quick. So how much else is there any other changes you're thinking of, Senator Sears?
Not that I'm aware of. There may be others.
Right?
Well, if you can do that in the bill, I'm sure amenable to it.
Right. Is there anything else that you want to review? I think everyone's got a clean copy of the amendment, right?
I just want to make sure I understand what we did on the operating the careless and negligent driving section.
Right, that's section 23. And
To make sure, that was the only thing that I was not sure it did what we wanted it to do.
Right, I ran it by Anthea, who does our motor vehicle stuff, and she agreed that it does do what you're trying to get at. The goal is to, remember, the situation that was being discussed was the circumstance where a defendant is charged with DUI, but pleads down to careless and negligent. And because of the way the ignition interlock program statute is set up and how it sort of dovetails with the separate statutory requirements for minimum suspension periods, there's a minimum suspension period for careless and negligent that doesn't exist for DUI statute. So even though DUI is a more serious offense, the person is either convicted of or pled to DUI offense, they wouldn't be able to get an ignition interlock right away. There's this minimum statutory suspension period that applies for a careless and negligent offense. So if the person pled down to a lesser offense of careless and negligent, which isn't unusual in the DUI context, they wouldn't be able to get the ignition interlock right away. I think DMV agreed that that is the status of the way the procedure works. So the idea is to make them equivalent in the sense that if you look at the new language on page 21, that the person pleads guilty to a reduced charge of DUI, at least with respect to their blood alcohol content. We deliberately excluded like commercial motor vehicles, bus drivers, those situations. But if they plead guilty to that, they plead guilty to a reduced charge of negligent operation after having been charged with DUI, and notwithstanding any points assessed against their license, they're still able to get an ignition interlock right away. So
it does what,
it's not, it obviously was some tricky drafting involved there, but I did run it by Anthea and Mike Smith at DMV. And there were some questions about how far did you want to go, but I think this reflected the target of defendants that you wanted to get at.
so if the
Michael Smith
person
said
had,
he knew Peggy that it was all good also.
okay. Well, that's comforting. So the only way that they wouldn't be eligible is if their points prior to the DUI were so high that they weren't eligible to continue to drive. Is that the points assessed for the careless and negligent don't come into play?
Correct.
That's the notwithstanding. Okay.
So if they already had a certain amount of points for something else, then the careless and negligent points don't count as far as, not that they don't count at all, but they don't count as far as their ability to get an ignition interlock.
Okay.
So they still have the points, but they'd also be able to get the ignition interlock, which is the same way that it would happen with the DUI, because DUI doesn't have any points. So that the idea was to make it equivalent.
Okay, and the Baruth language is in section 26. Shall occur so long as the contamination remains.
Yes, I think that was in there.
Yeah, it's line 4, page 22.
Thank you. Yes, that's right. Line 4, page 22. That's the environmental contamination statute of limitations accrual section.
Is the makeup of the board in here? I've looked twice, I can't find it.
No, in the sentencing commission.
Sentencing commission,
No,
sorry. Oh, it's not.
section. No, it's just, so I think that's in here is an extension of their sunset, but so we have to amend that section.
Michelle read it to us the other day, because I asked the same question, but I don't remember the lengthy list of people that are on it.
You have the site though?
I'm gonna try to find it.
Thank you.
So Eric,
Yeah.
just double checking on page 14. On the NICS background check system,
Right.
does that mirror what we did in S4?
It does, exactly.
Okay, and so if one or the other didn't get past that, but the other did, that provision at least would go through.
Correct, exactly.
Great.
Yeah. And it's also okay, just from a more technical perspective from our, but we always want to make sure you don't want to pass different language in two different places, so, but it's the same, so. we're good.
Yeah. Eric, it is 5451.
5451.
Title 13, Chapter 169.
Perfect. Thank you very much.
You're very welcome.
So, and I think the other changes to the bill that you discussed the other day are also in those other sections toward the end. You just mentioned the extension of the sunset of Sentencing Commission center series. There's also the Sentencing Commission report on the definition of stalking, which I think this
Yep.
we had been talking about in the context of, I think it was S4 when it originally came up. So that study and report is in here as well. The domestic terrorism I mentioned as well, so that creates a new chapter, domestic terrorism chapter. Doesn't actually change any language in the existing terrorism statute, it just repeals it in one place and reenacts it within the new chapter. And then there might be a location in the
So
future.
it goes from 13 VSA to 20 VSA?
No, it stays in 13, but it goes in a different chapter in Title 13.
Oh, okay.
And that may be where, you know, next year or sometime you may think about whether you want to, if the paramilitary training camp statute passes, you may want to put that in that chapter in the future. It might make sense logistically.
I think we had discussed trying to figure out how to make it automatically go there and realized it would just be easier to do it once it passed. We had a lengthy discussion about that.
Yeah, that's exactly right.
Well, start miscellaneous for next year, Eric.
Yeah, right. That's a good spot for it. The language that's what's in the same section you mentioned. Senator, about, yes, right. That's on page 30, but it's in the same section of law. This is the language I think that DCF and the Defender General's Office and the State's Attorneys had come to an agreement on as to when it is that juvenile records, an exception to the juvenile records confidentiality. So that's, I believe, consented to language among all the interested parties.
Although it's giving me a little bit of stress from our expungement conversation that didn't go anywhere last year.
Right.
Sealing versus expungement.
Yep. Yep.
But it's nothing to do with expungement.
Right.
Yeah.
Right.
And we still, because of the conversation last year, we still have the two pathways, some expunged, some sealed.
Yeah, it just stayed status quo because it fell apart.
Right, that's what I remembered. I just checking my memory.
There is the basic issue is, from the administration's point of view, is they want to have the sealed records available for certain purposes, for certain lengths of time. And obviously expunged records are not available. And that's been the major, quite frankly, the major roadblock between Senate, the House, and the governor's office. Basically, the Attorney General has been on the side of having both Attorney Generals, the current one and the prior one, both have been on the side of sealing and not having them available. And sealing would save us hundreds of thousands of dollars. The cost of, Judge Zone can comment on it at a different time, but the cost to the judiciary in terms of expunging records is much higher than what happens in states that allow sealing. The sealing question is really who has access to sealed records.
Yeah. And I would, if I could, Senator Sears, I would just add on that I thought that discussion was going in the right direction, but the administration ultimately had what seemed to me completely unrealistic goals about how many parties could view the sealed records, including roadside stops. And so I thought the committee made exactly the right decision to drop that discussion, because then they got the status quo. So I hope the next time we go back to it, they will moderate their requests because we should find a way to rationalize those two tracks.
That would have been my hope. If you remember, at one point, we offered the compromise of having sealed records, access to them same as juvenile records, actually.
Yeah.
And they had tentatively agreed to it, and then withdrew that agreement.
Yeah. Not good.
So the day we thought we had a breakthrough, we didn't. At any rate, we have before us draft, which will now go up by one. I guess draft 2.2, Eric, if you add in that thing on the Sentencing Commission.
3.1 actually, yeah, but.
3.1, okay.
Yeah. And
So-
I can add it right now, take a few minutes, but it's.
So what? You go right ahead, yeah.
Yeah.
I think everybody's agreed that the chairs of judiciary should be or designate.
Oh, okay. Right. Yeah, hey, sorry, I didn't mean to call the wrong number. It's Eric. Don't do it, but.
Should I break for 5 minutes or stay live?
You're muted, Dick.
Why don't we just stay live? Or
I
is
still
it,
can't hear you, but you're not muted.
why don't we